The Office of the Judiciary this week issued a strongly worded statement about purported confusion regarding the duration of a warrant of arrest issued by either a magistrate or a justice. In terms of the Criminal Procedure Act, the Office of the Judiciary says a bench warrant never lapses and may only be cancelled under expressly provided for circumstances. A very good evening and a warm welcome, Namibia. My name is Daniel Nadunya and you are watching The Wheels of Justice here on NBC. Are we witnessing a storm in a teacup, or is the problem larger than what we think? Today, it's our endeavor to explain what the warrant of arrest is in detail. So the wheels of justice will be rolling in a moment. Welcome back. If you just joined us, this is the Wheels of Justice, and this session is officially in motion. Joining us for this episode are Mr. Eugene Lizazi Libeve, criminal law lecturer at the University of Namibia, and Mr. Mbanga Siomunji, a senior partner at Siomunji Law Chambers. Greeting, Leonard, friend, and good to see you again back on the Wheels of Justice.
Thank you.
Good evening. It's a pleasure to be here.
Now, I just want to ask with consent, do we have consent to basically have citizen arrest executed and limit your rights to freedom of movement for just 55 minutes? Mr. Siomunji.
Well, citizen's arrest, just like an arrest by a police officer, is one of the methods of securing attendance of an accused person to court.
Right.
Yeah, so that's where we must understand any warrant of arrest or any arrest. In fact, let's look at it from an arrest point of view. You know, an arrest is a method of securing attendance of an accused person to court. Yes. So now, typically, there's two types of arrest. There's an arrest by a police officer and the arrest by a citizen. Like you say, private person's arrest. So a police officer can effect an arrest, firstly, if there's a warrant of arrest that has been issued by either a magistrate or a judge, you know, and they make an application, and the people who make an application for a warrant of arrest is typically the Attorney General, prosecutor, or a commissioned police officer. Yeah, so an application is made to a magistrate or judge under oath, stating that the suspected offense has been committed in a certain area of jurisdiction of either the magistrate or judge, and then a warrant of arrest is issued, and then it has to be executed. Then there's circumstances where a warrant of arrest is not issued, and it is permissible for a police officer to arrest a private person. These are circumstances like if an offense is being committed in the presence of the police officer, or an attempt to do so is being done, or if a person is suspected of having committed a Schedule 1 offense. Now, Schedule 1 offense, I'll just quickly run through it, are offenses such as...
Yes. Does that then mean that I may as well execute a citizen's arrest on Mr. Siomunji for 55 minutes to secure your presence here on the Wheels of Justice?
Well, yes.
Right.
Loosely speaking, yes.
Thank you.
Yeah, if an offense has been committed in your presence, yes.
Thank you so much. Has an offense been committed in my presence?
Not necessarily.
But may I arrest you for 55 minutes?
Yes.
Without a warrant of arrest?
Yes. Private persons are authorized to arrest in terms of the
for the Wheels of
Procedure
Justice. Thank you so much, Leonard, colleagues. Yes, Mr. Siomunji, you were busy explaining circumstances by which a police officer or a peace officer may arrest somebody. I think you may just continue.
Yes, without a warrant of arrest. I think I explained the issue of warrant of arrest when it has been issued.
Yes.
Now, without a warrant of arrest, a police officer can arrest a person, first of all, if an offense has either been committed or attempted to be committed in their presence. They can arrest a person. Or if a person is suspected of committing, there's a reasonable suspicion, not any other suspicion. There must be a reasonable suspicion that the person has committed a Schedule 1 offense. Now, when you talk about Schedule 1 offenses, there are offenses like treason, sedition, murder, rape, robbery, kidnapping, escaping from lawful custody, housebreaking, fraud, forgery, uttering, arson, and so on. So these are Schedule 1 offenses. So if there's a reasonable suspicion that a person has committed such an offense, a police officer can, without a warrant, arrest such a person. Or if you are found with certain implements suspected to be used maybe in housebreaking and there's no proper explanation that has been given, you can be arrested. Or you are found to be having a suspected stolen property, you can be arrested. Or you are suspected to be a prohibited immigrant, you can be arrested. Or you are suspected to be a person who was ordered by court to pay a fine, and such date lapsed and you didn't pay a fine, you can be arrested. So these are some of the circumstances that warrant a police officer without a warrant of arrest to arrest a person.
Mr. Libebe,
Yes.
any addition?
In addition, I think he has said enough. I think perhaps it's just better to understand what a warrant of arrest is, which is normally a document that is issued upon application, as my colleague has said, by the magistrate or a judge of the High Court. Obviously, a warrant of arrest, when it's presented to the suspect, it obviously has to contain the details of the alleged offense to have been committed and the details or the names of the person that is to be arrested. And the person being arrested can always demand for the production of such a warrant of arrest in the case where the arrest is made with a warrant.
Now, how is an arrest which is essentially, or which essentially limits one's rights, basically is justified? Mr. Libebe, how do you justify that?
Yes, we have constitutional rights, and of course, our constitutional rights are not absolute, let's say. They may be limited in certain circumstances.
Yes.
And I think that's where the Criminal Procedure Act comes into place to try to balance the rights of the accused person and also trying to allow the police to maintain law and order. So if you have rights, you also have responsibilities towards, the rights of other persons. You may not violate the rights of other persons and not be subjected, to the judicial system or to the justice system. So your rights, yes, you have rights to liberty, right to privacy, to dignity, but those rights will be limited in the circumstances where you commit offenses.
Yes.
And it's in the best interest of justice and also public order.
Yes. Perhaps let's again take it a little bit slow, Mr. Siomunje. Some arrests are basically made with a warrant of arrest and others without a warrant of arrest. How, maybe, what is perhaps the difference, and how will an ordinary citizen know that this arrest, although without a warrant of arrest, was justified?
Firstly, with a warrant of arrest, is as a private citizen, you can demand to see that warrant of arrest.
Right.
And once you make that demand, it must be shown to you. And you must see that, yes, indeed, it's a warrant of arrest with your details issued for your arrest. And then if it's without a warrant of arrest, as I indicated, I'll just run through the categories again. It's
perhaps before you run through the categories, how will an ordinary citizen identify that this is an authentic warrant of arrest? Perhaps by looking at the issuing officer?
Look, typically, police officers, particularly detectives, do not wear police uniform. But obviously, all police officers carry their appointment certificates. So a police officer, before arresting you, will introduce themselves, and they will indicate that they're arresting you and the reasons for your arrest. They'll indicate that to you.
Right.
Yes. So you will know that that is the police officer, although maybe they might not be, dressed in the police uniform.
Yes, and you rightly said one should basically, or could basically, or have the right to basically demand for the warrant of arrest to be shown to them.
Yes.
How do they know the warrant of arrest is authentic?
Well, you will see. I mean, you will see the warrant of arrest as indicated by Mr. Libebe, that it will contain your details.
Right.
It will contain your details. It will contain the alleged offense that you've committed. so you'll be able to see all those details there, to satisfy yourself. That's why we indicated that, upon demand, the warrant of arrest has to be shown to you.
You will also be able to see whether it was issued by a judicial officer
Yes.
or it was
Yes.
issued by basically a peace officer.
Look, the people who issue warrants of arrest are magistrates or judges.
Right.
It can't be issued by a peace
police
officer. No.
So if it's signed by a police officer, in that case, it cannot be concluded that it's a valid warrant of arrest.
Exactly, then it's defective because warrants of arrest as per the Criminal Procedure Act are issued by magistrates or judges.
Right. Mr. Libebe.
Yes. So in addition, if you are concerned with the genuineness of the warrant of arrest, of course, you can check whether it bears the stamp of the magistrate's court as well.
Yes.
To ascertain yourself with the authenticity thereof.
Yes.
Yes.
Again, let's take it slow by basically going through what requirements ought to be satisfied or to be met in the absence of a warrant of arrest, Mr. Libebe.
These basically, the Criminal Procedure Act says you can make an arrest without a warrant in certain circumstances. For example, if somebody commits an offense in your presence, you can arrest that person if you are a private person or a peace officer in the circumstances, or you reasonably suspect that the person is about to commit an offense or perhaps is in possession of stolen property or drugs, for example.
Yes.
You can arrest a person. So there are circumstances outlined in terms of legislation or the law in which you can arrest a person without a warrant of arrest.
Perhaps what is the idea around, what was the thinking of the lawmakers when they gave that basically kind of provision for one to effect an arrest even without a warrant of arrest, as long as perhaps maybe the crime is being committed
Yes, yes.
in their presence?
The intention of the legislature in doing this was because sometimes if you wait to obtain a warrant of arrest, you would defeat the purpose of the arrest. Say, for example, you see somebody committing an offense and you leave that person to go obtain an arrest, a warrant of arrest from a judge or a magistrate. By the time you come back, obviously you find that person has fled from the scene. So to avoid such circumstances, you'll always have to make an arrest if there is no warrant in the circumstances.
Yes.
Yes.
Mr. Siomungi.
Yes, and just in addition, the police are mandated to maintain law and order in society. So it would be a chaotic kind of situation if, one, sees an offense being committed, but then you cannot do anything. You have to run and then obtain, go and apply for a warrant of arrest. By that time, the offense has already been committed, and maybe the person has already fled. So it would lead to a situation where there is a chaos and anarchy in society. So to guard against that, that is why, as Mr. Libebe said, police officers as well as private citizens are permitted to arrest without a warrant in certain circumstances.
So who may effect an arrest? Perhaps this is for us to understand the difference specifically between a citizen's arrest and its application versus an arrest by a law enforcement agent.
Well, private citizens, as indicated, the provision is given in the Criminal Procedure Act. Private citizens can arrest. For example, if I see a person breaking into a house.
Any private citizen?
Yes,
right.
Yes. Any private citizen can effect an arrest. I see a person breaking into a house. I can arrest that person. And obviously, I'll take that person to the police station, to the officer and say, this person, I found him doing A, B, C, D, and so on. Then the law enforcement officers will take charge. Or if a person is escaping from lawful custody, I see police are chasing a suspect, and I'm in that vicinity, maybe I'm the nearest person to that suspect, I can arrest that person. Or in fact, the Criminal Procedure Act mandates me, if I'm called upon to assist in the arrest or detention of a person, I should oblige. Otherwise, it amounts to a criminal offense.
Hold on. Let's just make that clear. Am I understanding you well that basically a police officer may ask a private citizen's assistance in arresting a suspect.
Indeed so. Indeed so. The Criminal Procedure Act actually says that any person within the Republic between the ages of 16 and 60, when called upon, by a police officer to assist in the arrest or detention of a suspect, should oblige. Otherwise, if you don't, then it amounts to a criminal offense.
Well, I don't know. Who is responsible then for the safety of that private citizen? Especially should the suspect be armed or basically a person of perhaps suspected to be a dangerous person?
Obviously, I don't think a police officer being a trained person will ask you to assist in the arrest of a person who is armed. Obviously not. You have to look at the circumstances. I don't think a police officer would just unnecessarily endanger a normal public member's life. In such kind of circumstances, they will not. But if it's just a person who is just fleeing, they have no weapons and so on, and maybe you are the person nearest to them, they can call upon you to assist.
Right.
But obviously, you have to look at your own safety. If your refusal to assist is justified, then that does not amount to an offense, because you have a right to life. You have a right to protect your own life. That is the first thing. So that cannot amount to an offense.
Yes. Perhaps, Mr. Libebe, who is responsible for the well-being of an incarcerated suspect when the investigating authority is not necessarily perhaps the National Police, maybe it's Anti-Corruption Commission?
Obviously, we have other investigating authorities in Namibia, such as anti-corruption officers and others. So what normally happens is that when these people apprehend suspects, they always put them in police custody. So these suspects will be under the custody of the Namibian police. So the Namibian police will give them food and will be responsible for their well-being while in custody. Yes.
No, and there are some suspects that are arrested within the jurisdiction of Windhoek and detained somewhere at the airport, Hosea Kutako Airport. Perhaps, let's perhaps talk about the issue of jurisdiction and where a suspect need to be detained. Is it lawful that one is detained or is arrested from Windhoek municipality area and is taken to a different jurisdiction for detention? Mr. Siomonje.
Well, you see, warrants of arrest are jurisdiction or district specific. If you're arrested within the jurisdiction or district of Windhoek, you must be detained in that district, because that's where the warrant of arrest applies. So then with regard to your next question, the issue of whether you can be detained at any other police station, as long as it falls within the district, you can be. And normally such kind of decisions are made looking at logistics. Right. For example, if the Windhoek police station where you're supposed to be detained is full, look, you cannot now pack an already packed cell. And if maybe the CI's police station cells are relatively free, and it falls within the district of Windhoek, you can be sent there. Or whether it's Vanaheda or Chomwisa police station and so on, as long as it's within the district of Windhoek, or the district specific where the warrant of arrest has been issued.
Yes. We also know that the correctional facility is supposed to be reserved for people that are already sentenced. But under what circumstances a trial awaiting suspect may be detained in a correctional facility? Mr. Libebe.
So normally there are special arrangements made for special cases.
Right.
So for example, if law enforcement officers are being arrested, you cannot mix law enforcement officers with normal citizens in the police holding cell. So you would make provision for these law enforcement officers because it's in their best interest, it's for their safety and other considerations. So that's why you find that some people are being held at the correctional service or at the airport because of these various reasons, for their safety and also to ensure, the smooth administration of justice. Because you cannot put a police officer to share a cell with someone he has arrested in the past, obviously you are endangering the life of that person or police officer.
And for other citizens, private citizens, arrested and kept in correctional facilities?
Yes, again, like my colleague mentioned, it could be, for example, for logistical reasons. It could be that the police, cells are full, and then you make those arrangements with the correctional service to provide you with holding cells.
Yeah, but then who makes that decision? Whose decision is that? Whether to keep them in the correctional facility or basically in a police holding cell?
The Ministry of Safety and Security.
Okay, and is there perhaps an exemption, or is there perhaps a formal application that needs to be brought before the minister and approval is given, or basically how does it happen? Because
not that I'm aware of, but it's
yes,
common practice that you may not, in certain special cases, especially those involving, law enforcement officers, you may not combine these people with the ordinary citizens because of those safety, considerations and other factors in those circumstances.
yes.
Yes, but I don't think it's any violation of any right in doing so. I think it's justified in the circumstances that certain special people, special cases be treated in a special way.
Right.
Yes.
Perhaps another issue that keeps making headline relates to the amount of permissible force that can be used during an arrest. Mr. Siomunji, if you can just help us or remind us what the law stipulates insofar as minimum force or maximum force and the use thereof.
Yeah, the Criminal Procedure Act does not indicate any maximum force,
right,
but it just talks about minimum force. Because we have to approach it from the premise that, once a person has to be arrested, they have to be brought before a court, and once they're brought before the court, they have to, once they're arraigned, then the normal judicial process will take place. So the effect of bringing a person to court, they have to be arrested. Now, of course, you find circumstances where people resist, You can't resist what is lawful. So once a warrant of arrest has been issued or a crime is being committed in the presence of that police officer, which gives them justification to arrest that person, they must be arrested. If you resist, then the law, particularly the Criminal Procedure Act, prescribes minimum force to be used. So that minimum force should be equivalent to what is required for that person to be subdued and arrested. So depending on the kind of resistance that they offer. In fact, it even goes further. The Criminal Procedure Act even states that if within the course of effecting an arrest, the person who is fleeing, the suspect who is fleeing, there's no other means, to arrest them other than to kill them. It's what is called justifiable homicide. Of course, that might seem like it's an extreme case, but it comes from the premise that a warrant of arrest has to be executed.
Thank you so much. You are watching The Wheels of Justice. In the interest of the human rights of the esteemed panel, we'll take a brief adjournment before we return to welcome your calls and contributions. So stay tuned. Welcome back, Namibia. Should you have a question for our experts, the number to dial here in the studio is 061-291-3417. That is 291-3417. We request you to keep your interventions short and sweet. So your calls are now welcome. Now, before a break, we were busy explaining about minimum force, and you say there is basically no maximum force. But again, maximum force might actually be what you said, justified homicide. But what then amounts to an unlawful arrest? Because you said one can basically, or one should not refuse a lawful arrest, isn't it?
Yes.
What is the opposite? Yes, Mr. Libebe, let's go.
Yes, so basically there are basic requirements of a lawful arrest.
Yes.
So when you do an arrest, there are certain things that you need to obviously observe. So whether you have a warrant or without a warrant.
Yes.
For example, you should be an authorized person to make an arrest. For example, police officers are authorized to make an arrest. You must also inform the person that you are arresting of the cause. Why are you arresting that person?
How about a citizen's arrest?
What about the citizen's arrest?
Yes.
So it could obviously depend on the circumstances of the case.
Because the arresting person is
not
authorized.
The private person is also authorized to arrest.
Okay.
Yes. You may also arrest as a private person. But if you are arresting as a peace officer, obviously you will have to state the reason as to why you are arresting that person. And if there is a warrant of arrest, you need to produce that warrant of arrest and show it to the person that you are arresting. And of course, there's also constitutional requirements that come into play. You'll need to inform that person in the language which he or she understands as to why you have arrested that person, and their basic rights, such as the right to legal representation, the right to remain silent and not incriminate themselves.
No, if I may just add, obviously when a citizen is performing what you call a citizen's arrest, you can't expect them to act as a police officer. Police officers are trained in circumstances like that. A citizen would, by all means, most probably just arrest the person and then take them to the police station. You can't expect a private citizen to inform the person of the reason of their arrest and inform them of their rights and so on, which they might not know. But as rightly said, the Criminal Procedure Act, gives provision for a private person to effect an arrest. You can't just ignore if an offense is being committed in your presence or attempted to be committed, or a person is, escaping from lawful custody, or you reasonably suspect that they've committed a Schedule 1 offense. You can't ignore that for law and order. That's why the Criminal Procedure Act, gives provision where a private citizen can arrest.
Now, the Judiciary this past week issued a directive about the duration of a warrant of arrest issued in terms of Section 43 of the Criminal Procedures Act 51 of 1977. Maybe before we get into the particulars of that very directive, maybe what is the understanding of what maybe brought, or what was the concern that brought rise to that particular directive?
I think it's the issue of maybe confusion in certain quarters that might have occurred in terms of whether a warrant of arrest issued expires or not. Because by law, I think a warrant of arrest does not expire. It either has to be executed or it is cancelled by a person who issued it or a person of like authority. So maybe some people might think, okay, if a warrant of arrest is issued and then it stays for some time, no arrest is effected, it just expires. So the clarification which was given from the Magistrates Commission was that a warrant of arrest does not expire. It either has to be executed or it has to be cancelled in court by the person issuing it or a person of like authority.
Mr. Libebe, that perception or that misconception is quite common with regard to traffic fines or arrests that are related to traffic fines, isn't it?
Yes. But like my brother has mentioned, obviously a warrant of arrest will remain in force until executed. Or if perhaps the suspect dies and then you make an application to the magistrate to have it cancelled. Yes.
Perhaps then let's have regard to the directive that was basically given. Maybe in simple terms, if we can just explain what it meant to explain.
Well, the directive basically explained, I believe it's in terms of Section 43.
Yes.
First of all, people who are mandated to, apply for a warrant of arrest. That is the Attorney General, a prosecutor, or a commissioned police officer. Now, a commissioned police officer is the police officer from the rank of inspector going up. So these are the three categories of people who can apply for a warrant of arrest. And the application for a warrant of arrest has to be either before a magistrate or judge to satisfy them to say that the suspected offense has been committed in their area of jurisdiction in a particular district, and there's reasonable suspicion that indeed it has been committed, And this information has to be given under oath. So it has to satisfy, to be the satisfaction of the magistrate or judge that indeed, a certain offense has been committed. That is when they'll issue a warrant of arrest.
Right. Let's kindly flesh out the instances where a wanted person is traced in a magisterial district that is different from where the crime was committed. What ought to be done in this case?
In such cases, obviously a warrant of arrest will not apply, since a bench warrant only applies in the magisterial district where it was issued. So in such cases, obviously you'll make application for a warrant of apprehension, which some could call a J50, which allows you to arrest or comprehend that person wherever he might find himself in Namibia, within Namibia. So if you are outside of that court's district or jurisdiction, you may still be arrested by use of that warrant of apprehension. And then what happens is that the district court in which you are being apprehended will make a transfer that you appear and answer in the district where the offense was committed. Yes.
A J50, surely, Mr. Namanje, Siomunje, pardon me, does not apply in a foreign jurisdiction.
Indeed so.
It does not apply.
No, it cannot apply because you have to look at, Namibia, just like all other countries, are sovereign states. So the laws that we have, our constitution applies to our country. The laws that we have apply within our jurisdiction, within our country. So there's no way a J50 can apply outside the borders of Namibia. In fact, what applies outside the borders, there's what you call extradition. Right. If a person is outside the country, a wanted suspect and so on, so you find that it's an issue of government-to-government cooperation where extradition proceedings are commenced, where you attempt to extradite that person back to the country of origin where they can face the alleged crimes that they are being wanted for. So maybe just to add on the J50, particularly with regard to the directive that was issued by the Magistrates Commission, particularly Mr. Shuveni,
yes,
is that a J50, applies in all districts of Namibia. It's not district specific. A normal warrant of arrest is district specific, but a J50 applies to all districts of the country. So once a J50 has been issued, wherever you are in the country, you can be arrested. And if there was already a warrant of arrest that was issued in that particular district where the alleged offense emanates from, then it has to be attached to the J50 to be cancelled, in that particular district of its origin. Because a warrant of arrest can't just be left hanging. It either has to be executed or it has to be cancelled.
What implication perhaps exists for magistrates who do what is not legally permissible and not within the confines of the law, Mr. Libebe?
Magistrates, like any other persons, they are equal before the law. And if they violate any criminal law and any other law of the state, they will be subjected to the courts, just like any other individual. But of course, there are certain offenses also that may be covered by their own code of conduct, which are internal mechanisms to deal with cases of misconduct. So obviously, if you are aggrieved by the conduct of a magistrate, you can open a case or you can report to the Magistrates Commission. But if it relates to procedure and practice in the Magistrates Court, of course, there are also mechanisms where you can appeal the decision of a magistrate, or those decisions are subjected to review by the higher courts. Yes.
Now, perhaps what could be some of the sanctions for an officer who is said to have conducted himself in a way that is not expected or prescribed by the law?
Are you talking about a police officer or a judicial officer?
A judicial officer.
Well, a judicial officer, if you have to look at, for example, the magistrates are creatures of statute, they have to abide by the Magistrates Act. If it's a High Court judge, there's the High Court Act. So, there are parameters by which they have to act and, perform their duties. And their relevant bodies can take action against them if they transgress what they're supposed to do. Like Mr. Dibebe rightly said, the Magistrates Commission is there for magistrates. So amongst other things, they deal with promotion and discipline. So obviously, if a magistrate is seen to transgress what they're supposed to apply properly to dispense justice, then the commission will investigate and then take appropriate action if they find that person wanting. And also, with regard to judges, there's also the Judicial, Service Commission and so on. So all those, there are mechanisms to make sure that justice is dispensed fairly,
Yes. 061-291-3417. That is 291-3417. That is the number in the studio. For your questions or contributions, your calls are welcome. Now, should a warrant have been unlawfully obtained and the suspect dies during the arrest, will there be implication for the authority who issued it, or perhaps for the arresting authority? Are there implications?
What do you mean? Is that the warrant was authorized by a person who is not supposed to be?
A warrant was unlawfully obtained. And while unlawfully obtained, a peace officer is busy carrying out an arrest and the suspect dies, perhaps because of minimum force or maximum force.
Of course, the resulting arrest will be categorized as unlawful arrest, and of course the court can make a determination. If there's a lawsuit, you can pay damages for whatever. But I don't get your question, because if you say a warrant was not authorized, are you saying it was not issued by a magistrate or a justice, or what do you mean if a warrant is not authorized?
Let's take that as a scenario where an arrest is being carried out and it was not issued by a magistrate, or perhaps maybe it was issued in a different jurisdiction.
If a warrant was issued in another jurisdiction, it
Yes.
cannot be applied. If it was a bench warrant, it cannot be applied or executed in another jurisdiction.
It becomes an unlawful
Yes,
warrant,
yes.
or not lawfully obtained, isn't it?
Yes.
What happens if during that arrest, that suspect dies?
The arrest will become unlawful itself.
Right.
Yes, and any subsequent detention thereof. But in the case that you die, obviously, if the arrest was unlawful, you may be liable to pay damages.
Right.
Yes.
Mr. Siomunje, have you experienced any such scenario where an arrest was basically carried out or a warrant was unlawfully obtained and perhaps a suspect died?
Not to the extreme case where a person died, but unlawfully obtained, yes. Yes, right. I've had those kind of cases. And normally what happens in those cases is that you can take action against, of course, the police fall under Ministry of Safety and Security, so you sue the state for damages, so because the arrest remains unlawful. So what happens to the person who was subjected to that cruel, degrading,
you
and
just have to hold your thought there. We have Mr. Martin from Windhoek. Good evening. Mr. Martin, good evening. Well, we don't seem to hear Mr. Martin. Mr. Siomunje, you can continue.
Yes, so as I was saying, that the person has been subjected to that cruel, degrading, and inhuman treatment where they've been deprived of their liberty. They've been put in cells and subjected to all manner of things wrongly. So surely somebody must pay for that. So that's the civil action that one can institute against the state, to be compensated for, the gruesome ordeal that they went through.
Maybe, perhaps, while at it, it's unrelated, though it's connected, because we are also talking about magistrates who are also judicial officers. The Magistrates and Judges Association of Namibia expressed deep concern over the safety and security of judicial officers following an arson attack on the Hobabis Magistrate Court. Maybe what's your take on that, Mr. Siomunje?
The concern, of course, is genuine. I think we also express that concern, but what it shows is that there is these government institutions are not guarded. Now the question is, why isn't an important institution like a magistrate's court guarded? Because anything can happen. There is dockets there. There's equipment and other things that belong to the judiciary that they use in dispensing justice. Prosecution and judicial. Now, why wasn't the place guarded? Because by law we know that a branch of the police that guards government institutions is the Special Field Force. So why wasn't the Special Field Force guarding government building, an important institution such as a court? So it exposes the porous nature of events. So although we are talking about it now, the issue is it shouldn't be a case of medicine after death. Why wasn't the building guarded all along? Because we do not know at this juncture whether it's a person from the same court. It might be an internal person who is aggrieved by something, who caused the arson, or it might be a person from outside. That is not known. But irrespective of that, it just shows that there's no security there. So it's an issue of there must be security at government buildings. Important institutions such as courts, they must be guarded.
Mr. Libebe, your take, sir?
I think the conduct itself actually compromises the independence of the judiciary in some way and also hampers the smooth administration of justice. But like my brother said, it all melts down to security. So it's up to the state to tighten up security and protect these institutions and the people working in these institutions because, at the end of the day, these institutions are mandated with, the administration of justice. We want to see justice being done without any obstructions from these types of conduct. Yes.
Thank you so much. You are still following the Wheels of Justice here on NBC One. We'll be back in a jiffy for the jargon of the day. Welcome back. Now we go on with the jargon of the day. Perhaps, Mr. Libebe, explain what bench warrant is.
A bench warrant is a warrant which is issued by a magistrate, and it's only applicable in the magisterial district in which it was issued, and it can only be executed in that district.
Right. And Mr. Siomunje, what a peace officer is?
A peace officer is an officer that keeps public law and order, and in our circumstances, that is synonymous with a police officer. So police officers, we know that they're the ones that are mandated to keeping law and order in our society.
Thank you so much, Leonard Friends. But are there any unresolved matters that you wish us to have regard to before we say, before we call it a day? Mr. Siomunje, let's start with you. Final remarks.
My final remarks would be on the issue related to the safety of the magistrates' courts. I think I would call upon the Office of the Judiciary to really take a serious look at it. Courts are serious institutions for dispensing the justice. So it's disturbing that courts are not guarded, because we wouldn't want to hear in the near future that another court has been set alight by, through an arson attack. So I think we call upon them to seriously look at that. If nothing has been done, for the other courts in future, it should be done now. They must be guarded just like other government institutions.
Mr. Libebe, final remarks.
Yes, I think for myself, just to the law enforcement officers, especially police officers, I think they must have regard to the fundamental rights and freedoms in the Constitution when affecting arrest.
Right.
Yes.
Thank you so much. Thank you for making time for the Wheels of Justice, and thank you for accepting a citizen's arrest for basically you to render your service pro bono to members of our public.
Thank you.
Thank you.
Thank you.
With that, we've come to the end of tonight's episode. We trust that we've deepened our individual and collective understanding insofar as the pertinent matter of warrant of arrest is concerned. This session is adjourned.